Law Simplified with Justice, the new informative, educative, and thought-provoking program is what you need to keep abreast with law and politics. This exciting and truly refreshing program is anchored by Justice Maduforo, a solicitor.
Ladies and gentlemen, it's been a soul-searching discussion here with my colleague. We've been dissecting sole responsibility under the immigration rule, those under 18 and those above 18 years of age as well.
Law Simplified with Justice understands that law is a powerful driver to human behavior. It is therefore poised to simplify the law and get you to take action.
Bring it to your doorstep and simplify it the way that you will understand.
Contact Justice by calling 07931 727 597 or email lawsimplifiedwithjustice@yahoo.co.uk. Law Simplified with Justice, bringing the best to the audience.
Would the individual circumstances of one be used as a parameter to judge the other application, or it is solely based on the merit of your case on the face of it?
Absolutely. 2 points here. The merits of the case, that's really, really significant. And then the next point is, of course, the law of precedent, as you're well aware of. If a case has been decided in a particular way, it is highly likely, in fact, it is almost mandatory, it is almost law, that similar cases are decided in a similar way.
Right. Okay. Viewers, you could hear us discuss these issues. It's basically discretionary leave to remain in the United Kingdom. You may be affected, or somebody else may be affected, or somebody you know may be affected. You don't sit down. What you need is to pick up the phone and you call and say, how can this circumstance of this person be used to lodge an application? Mr. Wallaby, let me deal with another issue here. Now, we know that discretionary leave application is just a discretion on the Home Office. It depends on who they want to grant or who they don't want to grant. Is there a circumstance whereby a very hopeless case on the face of it could actually get a very positive outcome, a response from the Home Office? Because we are dealing with discretion here.
Absolutely. So let's go back to first principles, really. Where does the Home Office get its power to grant leave to remain? It is because Parliament has given the power to the Secretary of State to make rules for the regulation of immigration control. So in theory, the Secretary of State has the power to make a man on the streets of Lagos a British citizen if he so desires. It's basically got that power if he wishes to use it. So therefore, really, it's entirely at the discretion of the Home Office to grant any particular application, even if it seems disastrous to any third party looking at the at that person's particular circumstance.
Okay. Now, another question in the course of my practice, most clients will ask questions in relation to such application is, once they've lodged this application, what is their status in the United Kingdom? Because it always comes in, and most of them have this feeling that once they've lodged this application, whether or not it's granted or not, they now assume a status in the United Kingdom. Now, in as much as it doesn't constitute legal status, but it does significantly, positively aid such applicant in terms of removal.
Indeed, that person would have an application pending with the Home Office. The technical term is that they've engaged with the authorities. So it's different from someone who is absolutely at large, who hasn't engaged with the authorities at all. So putting in an application to the Home Office means at least you're trying to rectify a bad situation, you're conscious to your circumstance, and you're looking for the best way out of that position that you're in.
Yes.
So to an extent, it does assist you. And remember that these types of application could be pending for a significant period of time. Now, while an application is pending with the UK Border Agency, it's somewhat difficult for you to be picked up and put on a plane and sent away until at least you get a decision on your application.
Yes, until you get a decision on that application. That is a very important factor here. Remember, you must have now engaged with the Home Office. How do you engage with the Home Office? Make your application. It doesn't matter the situation that you are, your circumstance, you must engage with the Home Office. It is needless to be on the run. Because when the Home Office, the arm of the law, catches up with such a person, it becomes that the person is now voluntarily or intentionally flouting the immigration laws of the United Kingdom. You must engage with the Home Office. How do we engage? Look at the circumstance. You may look at it and say, I don't have any basis to make this application, but you never can tell. You need to engage with the legal representative, speak to us, and we will advise you, we will diagnose your circumstance and see that really there is something inside of you or a circumstance that will warrant you to make such application. Ladies and gentlemen, the phone lines will be open and we may want to take your questions. Please, when you call in, go straight to the question. We will attempt to do justice to that. And also, if you want to contribute to this program, we're very much happy to take your contribution as it is. Mr. Wallaby, going back on Article 8, it is important, obviously, such applications at times get refused. That's correct. They get refused once in a while. Now, that application has been refused. Now, such applicants have no right, in some cases, to appeal such decisions. It's a different water we're going to now, but we want to touch into it as a post-application. What happens post-application? That application has now been refused by the Home Office, and this applicant is now, what next can I do? Is there any other way we can resurrect that application and keep it ongoing? At least to see there are one or two merit in there, one can take that application up.
Right, as you rightly said, it's become a lot more technical than what we started off with. So if someone has an Article 8 application, for example, which has been refused without the right of appeal, the court system in the United Kingdom provides an avenue for you to challenge that decision to refuse. The best way to challenge such a decision would be to go to the High Court and apply for a judicial review of that decision to refuse you. So you might want to approach it by challenging the decision to refuse you a right of appeal, i.e. the Home Office you'll be alleging that they should have taken an immigration decision rather than simply issuing you with a notice of refusal without taking a decision on removal at the same time, which normally would trigger an in-country right of appeal. So you would go to, such an applicant would go to the High Court and file an application for judicial review. You might, as you are well aware, there are 3 grounds for challenging an application under judicial review. You might say this decision is irrational. Look at my circumstances. No reasonable decision maker, looking at my circumstances, could have come to the decision to refuse that you, the Home Office, have come to. That's one ground. That's irrationality. You might say that the decision is unlawful with reference to the Human Rights Convention. Or the third ground, you might actually say, well, you have not followed the proper procedure in refusing this application. So you've got various grounds to move for judicial review of a decision.
That's absolutely correct in that respect. It's another way. You see, that brings viewers to the point that you need to engage and see legal advice, seek proper legal advice in circumstance. Because it might be that you are in a situation whereby you've made that application yourself, it's been refused. I probably didn't know what next to do. You see, it's important. This is a country that is founded on law, and it's important that this comes in. The question now is, what next from there? You need to seek proper legal advice. The phone lines are open, and we'd love to take your calls. We'd love to take your contributions, and as you can call in, we will do justice.
Law Simplified with Justice, the new informative, educative, and thought-provoking program is what you need to keep abreast with law and politics. This exciting and truly refreshing program is anchored by Justice Maduforo, a solicitor.
Ladies and gentlemen, it's been a soul-searching discussion here with my colleague. We've been dissecting sole responsibility under the immigration rule, those under 18 and those above 18 years of age as well.
Law Simplified with Justice understands that law is a powerful driver to human behavior. It is therefore poised to simplify the law and get you to take action.
Bring it to your doorstep and simplify it the way that you will understand.
Contact Justice by calling 07931 727 597 or email lawsimplifiedwithjustice@yahoo.co.uk. Law Simplified with Justice, bringing the best to the audience.